Be it Google, Facebook or any other local business, whenever we visit their website, we do not visit their website by going to their IP addresses. Rather, we put facebook.com, google.com, you got the point. Here, we can construe that the domain name is either the brand name or very strongly connected with the brand name. Say if there is apple.com which sells electronic products. A person might go to godaddy.com and try to find appleelectronicproducts.com and try to register himself as the owner of that website. And if the domain is available, he will also get the same. With the hope that people get confused and believe that this website appleelectronicproduct.com is some official website of Apple, and people end up buying those products, and the person who registered himself as the owner of this Apple electronic product unduly get the commercial benefits. This is a very common phenomena, and trust me, I have been dealing with these kinds of cases in courts on almost a daily basis. So let's jump to this topic first and ask whether do we have any Indian laws which specifically deals with domain name disputes. The answer is no. We do not have any specific law per se which deal with domain name disputes, but we have plethoras of judgment which deal with these disputes, and we rely on those judgment to handle such disputes. The first ever Indian case with respect to domain name dispute was filed in the year 2000 by yahoo.com. This was filed against a person who made a similar website with similar layout with the name yahooindia.com. Delhi High Court held that passing off will also be applicable in the case of domain name disputes. Consequently, yahoo.com got the protection it sought from the court. Further, in the case of Satyam Infoway Limited versus Sifinet, Supreme Court held that a domain name may have all the characteristics of a trademark and could found an action for passing off. So whether does this mean that trademark and domain name are the same thing? And the answer is no. Supreme Court in the same case clarified that even though both of these can get the trademark protection, both of are different in nature. Let's talk about the distinction in detail in some next video, but right now let's talk about the dispute resolution process. Say if you are the victim here and you got to know that someone is running a website with similar name as yours, you could either go to civil court, high court as the case may be, or you could go for private arbitration as prescribed by ICANN. Now from the starting of the video, I have already explained the stance of the Indian court pertaining to the domain name disputes. Right now let's talk about this private arbitration. For generic domain like .com, .org, .net, we follow UDRP. For Indian domain, that is .in domain, we follow INDRP. Under these policy, you could either plead for the cancellation of the infringing domain, or you could ask to transfer that domain to in your name. In most cases, people go for the latter part, that is transfer of that infringing domain in the name of the victim. Now if we see if a person should go for litigation or arbitration, arbitration definitely is a less expensive process. It is fast and less expensive. But that doesn't mean that you should abandon litigation, because in the case of arbitration, you will be getting only two remedies. Either you will get the infringing domain transferred in your name, or you could get it cancelled. You won't be getting any compensation. But in the case of litigation, there is a very high chance that court could grant you some compensation. For example, Yahoo got rupees 5 lakh of compensation for the website called Yahoo Kochi. Shine.com got the compensation of rupees 10 lakh for some website called Click to Shine, and there are thousands of such examples. Now if you are a victim of such infringement, it's highly advisable that you go and engage some lawyer, because limitation period in the case of trademark infringement is only of 3 years.